Okay, thank you. Well, I was asked to talk to you about the Ever Given potential liabilities insurance cover. Basic idea is basically to use the Ever Given as a sort of a hook to look in some more details at some of the insurance law aspects that Ridian already talked about. I'm sure you remember the Ever Given incident, but just to remind you of the basic facts. 23rd of March, the Ever Given runs aground in the Suez Canal, completely blocking the canal. That's what you get with such a big ship. 6 days later, the Ever Given is refloated. The canal has been blocked, completely blocked for 6 days. 29 March, refloated, towed to the Great Bitter Lake, and there arrested by the Egyptian authorities and or the Suez Canal Authority. After the 29th of March, the canal was free again, passage could resume. But of course, by that time, you had already a big backlog of ships waiting to pass through. And finally, that's not related to the actual traffic anymore, but on the 7th of July, the arrest was lifted and the Ever Given was released and could continue its voyage to Rotterdam and there deliver the cargo. Cargo on board had basically not been damaged. Now, just as an introduction, and I thought this just straightforward because that's all quite obvious. As a result of this incident, the Ever Given had suffered damage. Actually, for such big ships, very limited, very small damage, primarily to the bow of the ship. Clearly, hull damage, as Ridian has explained, ship owners have what is known as hull and machinery H&M insurance. That's not too complicated. As always, as Ridian very correctly pointed out, read the policy. What is in the policy? And here you have a difference between what is called named or nominated perils policies, like the Internet Institute Time Clauses hulls in the English markets. You also have all risks policies for hull and machinery. Primarily in the French markets, in the German markets, they offer you, and undoubtedly you can also get all risks cover in the London market. But that's basically a decision that the ship owner has to make. How big of a cover do I want? And obviously, how much am I prepared? How much am I able to pay? All risks cover is obviously going to be more expensive than named perils. Maybe a word to the wise, and that ties in again with the message, read the policy. All risks policy, that's what insurers like to say. All risk does not mean all losses. As Ridian said, it's not that you can go to the insurance and say, well, I have a policy and I have a loss, so give me my money. No, you still need to make sure that you're within the terms of. For the Ever Given, of course, there would be no problem, not even under named perils, because perils of the seas, rivers, lakes, other navigable waters are standard covered under hull and machinery. So this damage would undoubtedly be covered under the hull and machinery of the Ever Given. In addition, because well, you have the damage to the bow of the ship, obviously you can't repair that simply while the ship is at sea. The ship needs to go to a dry dock. You have all sorts of additional costs, the dry docking itself, preparing for dry dock. You might need to go over there. As long as those costs are reasonable, they are also covered under the insurance policy. And the owners of the Ever Given will also get those costs back from the insurance. Second part of the straightforward liability, it's easy to see that such an incident gives rise to all sorts of liability. to the canal authority, to the government, to all the other ships potentially, etc. There, and as Iridian has explained, there you have the protection and indemnity, P&I, sometimes people call that banding cover, is available to cover many different types of liabilities. You can get these days P&I cover with obviously the P&I clubs, but if you want to also today with commercial insurance company, fixed premium P&I, that is also available. Look, generally, the cover that is available with commercial insurance companies is somewhat limited, somewhat lower than with the P&I clubs. For EU flagged vessels, vessels calling at EU ports, their insurance against maritime claims is mandatory. It's a bit of an exception to the general principle that ship owners, certainly in the old days, were free to decide what they wanted to insure or not. Nowadays, there has to be insurance. That's, as I said, that's the straightforward. The whole damage, the liability, that's quite easy. Let's have a look at the salvage aspect. Obviously, ship the Ever Given was blocking the Suez Canal. You couldn't leave it there. You had to do something. The first initiatives, obviously, were taken by the Suez Canal Authority. They acted as the main salvor. Not very successful, not at first. And then the owners called in a very well-known salvage company, Smith, a Dutch company. And it was, at the end of the day, Smith that actually pulled the Ever Given. If you look at the definition of what a salvage operation is in the London Salvage Convention, it's any act or activity undertaken to assist the vessel in navigable waters, any other waters whatsoever that is in danger. Clearly, what Smith has done there, the assistance that Smith has given to the owners of the Ever Given, that is a salvage activity, that is a salvage operation. Problem, but not necessarily a problem, but it became sort of a problem in this case. Salvage convention is not a mandatory convention. Parties are allowed to deviate from the salvage convention to decide differently. And in this case, and it's a bit strange because the Ever Given was, of course, a very well-known case, attracted attention all the world over. We're talking about huge amounts of money. And still, you see that you get a discussion afterwards between the owners and the salvors, or the alleged salvor Smith, afterwards about what exactly their contract or their alleged contract is. The owner says, okay, Smith has clearly provided services, but we had an agreement that those services would be provided on a tariff plus basis. Tariffs, scopic tariffs, basically, plus a bonus, and then possibly a reflotation bonus, etc. Smith said, and thus the argument of the owners was, well, that's all that Smith can ask for, these tariffs plus, but nothing more. Smith said, yes, that's true, there have been negotiations, and we did reach an agreement on tariffs, but there were all sorts of other things that we still had to agree on. So we never had a binding agreement. Thus, in other words, we are not bound by this fixed remuneration, fixed tariff. We can claim a standard salvage award under the convention itself based on the criteria of the convention itself. Obviously, this is something that is very fact-specific. It depends on what the parties actually, how the parties actually interacted with each other. Briefly, in this case, on the 23rd of March, the Ever Given goes to ground. Immediately, Smith is contacted. At that point, basically to give kind of in a supportive role to the SCA, but immediately on the 23rd of March, Smith is contacted. Next day, they're sending a commercial proposal on basis of tariffs, because that was what the owners had asked. Smith itself had proposed a Lloyd's Open form, but the owners didn't want to go that way. 25th of March, proposal had not been accepted yet. And Smith says, well, we do need some kind of assurance, otherwise we're not going to ramp up, as they say it. We're not going to spend more time, more money. So they get sort of verbal assurance indeed from the owner, say, yeah, we are going to engage you and never worry. Evening of 25th of March, a new commercial proposal, a draft rec hire contract. And then this is later turning out to be crucial. On the 26th of March in the late morning, the owners say, we agree with the tariffs plus the bonus as you have proposed. There are some details about the rec hire. The rec hire needs to be ironed out, but it's details, nothing. We're going to sign the rec hire any days. 27th of March, all day was spent. There was communication between the parties, but on other issues, not on the proposal, not on the rec hire. And on the 28th of March, the owners finally sent their comments, and not just a couple of details, but quite significant amendments to the proposed record. And then the next day, 29th of March, the agreement is indeed refloated. And then, of course, there's no point, no purpose in continuing negotiations, and there's never an actual contract signed. And the question is, was there, as the owners alleged, was there a binding contract on the 26th of March?
Which law is governing the law of the contract?
English law. Well, the alleged contract, of course.
Yeah.
And there was, in any case, an agreement that it would be English law. That was not disputed between. That goes to first the Admiralty Court, later the Court of Appeal. The decision of the Admiralty Court is quite interesting to read, because it has a very long and very detailed set of facts, statement of facts of what exactly happened between the owners and Smith during those 6 days. It really gives you an insight in how these things work in practice. Court says, well, the question that we need to resolve is whether the parties intended to be bound there and then on the 26th of March. The court says the burden of actually proving that there was such an intention to be bound there and then lies with the owners. The owner said, well, there's nothing, there are no words like subject to contract, subject to details in our emails between each other, so there must be a binding agreement. The court says, no, well, you can, of course, use these kind of words like subject to contract. It's a possibility, but not a necessity. You don't need to use these kind of words. In this case, it was, in the court's decision, clear from the actions of the parties that there was no intention yet to be bound there. As we have seen at certain points, Smith had threatened to stand down, to stop, or not to ramp up if they didn't get assurance. Who says, well, okay, that's in those circumstances, in those the type of negotiation between the parties that is to be expected. And it's perfectly possible that for Smith, the fact that we now had that on the 26th of March, they had an agreement on tariffs, that was enough to continue negotiations in view of a final process. The fact that you had this agreement on remuneration on the 26th of March and that you agreed to continue the negotiations, that does not show that then and there and then on the 26th of March, Smith already intended to be. Also, the fact that Smith had already undertaken work. They had already put together a team. They had sent people down to Egypt. They had already chartered in quite expensive tugs. So again, the owner said, well, that clearly shows that Smith must have considered itself bound, that they must have thought that we had an agreement, otherwise you wouldn't do that. Of course, says, no, that is what salvors do. They take risks, they take financial risks in the hope that something gets out of it. That does not sufficiently prove that Smith intended to be bound on the 26th of. The ultimate result of this case, and as I said, was later confirmed by the Court of Appeal, ultimate result is that there was no binding agreement between the parties. Obviously, that doesn't mean that Smith doesn't get any money. That means that Smith is now free to ask for a salvage award under the convention based on the criteria of Article 13, which undoubtedly, in Smith's opinion, was going to be higher, much higher than the tariff-based remuneration that the owners actually wanted. But I think it's quite illustrative, quite striking that even in such a high-profile case, you still can get into uncertainties and parties not actually knowing whether they have an agreement or not. Now, if we look at the insurance implications, in any case, there is money to be paid to Smith, whether it was contractual or non-contractual. It's clear that Smith provided services, that there will be some money to be paid. Under the salvage convention itself, such rewards need to be paid proportionally by the vessel and by the other salved property interest, primarily cargo. You might also have other things that are salved, but primarily cargo. But as far as insurance goes, this is an issue both for the owners of the Ever Given and for the cargo owners. For the owners, salvage awards, they will have cover for, as Ridian already briefly touched upon, owners will have cover for salvage awards. Whether they be contractual or non-contractual, that doesn't really matter. What is a bit remarkable is that salvage can come into the insurance cover in different ways. In some cases, the owner will declare general average to recover salvage expenses, and then the general average contributions are covered. Salvage awards might be explicitly covered as such under the policy, as a sort of a named expenditure that is for which there is cover. Or in some cases, if you can get them under the explicit salvage provision, they might even come in as sue and labor expenses, expenses that the assured has incurred to prevent or minimize an insured loss. Again, of course, we're talking about insurance. The only reason why an insurer has to pay is because of the policy, because of the contract. Expenditures, salvage expenditures, they must have been incurred and reasonably incurred to avoid or to try and avoid an insured peril. If you have named perils, hull and machinery insurance, and the ship is threatened by something that is not a named peril under your policy, you might still incur costs, expenditures to avoid that risk, but you will not get those costs, those expenditures back from your insurance. Cargo interests, as I said, they can also be hit with a request for a salvage award, at least under the convention itself. Under Dutch law, for example, that is basically excluded. The Dutch legislator has channeled salvage liability strictly to the owner of the ship, and then it's for the owner to recover that from the cargo. In most cases, like the institute cargo clauses, all three variations, the French cargo policy, that is covered. You have explicitly cover for what the cargo interests have to pay as salvage awards. ICC, BNC variations, those are named perils covers for cargo. There, the salvage charges are covered if they are incurred to avoid loss from any cause. Even though BNC are named, nominated perils clauses, salvage charges covered if incurred to avoid loss from any cause, except some causes that are explicitly excluded. Continental policies, with the exception of the French, which explicitly talks about salvage. Belgian, Dutch, German policies, they don't explicitly mention salvage. Doesn't mean that under those policies, as a cargo owner, you cannot get reimbursement for salvage charges. They bring that in under the general heading of expenditures to avoid or minimize insured losses. So even though salvage charges are not explicitly named, mentioned in the policy, there is still cover, but under this more general. And on the German market, they have a specific salvage and removal clause, deals with salvage, but also with removal costs, which can be very, very high, very expensive. The other aspect I wanted to talk about in relation to the ever given is the issue of delayed cargo. From a commercial point, from a normal point, if you ask any non-lawyer person, was there a delay? They're going to say yes, obviously. Although those other vessels, they had to wait for several days, and even after the 29th of March, when the canal was free again, the backlog obviously didn't immediately disappear. The Ever Given itself was blocked until July 21. So very obviously, the cargo clearly on board of the Ever Given, but also on board of all those other vessels, only arrived at destination later than was expected. How do we deal with that from a legal perspective? Well, the Hague-Visby rules, which is the major convention for capture goods by sea, they don't mention delay in delivery. They don't mention delay in delivery at all. And which, given the era in which the original Hague rules were written, that is obviously very understandable. We're still talking about sailing ships. We're talking about the early steamships. In those days, it's quite understandable that they didn't think they could hold a carrier liable for delay. Some people have said, well, Hague-Visby rules don't talk about delay, so that must mean that there is no liability for, there cannot be liability for delay under the Hague-Visby rules. It's excluded by the Hague-Visby rules. I personally think, and Belgian law, French law, Dutch law does not take that position. The position there is that the Hague-Visby rules simply do not talk about it. It's something that is not within the cover, within the scope of the Hague-Visby rules. So it's left to the applicable national law. And if cargo is delayed, you need to look at whether the applicable national law gives you any grounds, any possibilities to go against the carrier. The Hamburg rules, on the other hand, which is in force, but in a limited number of countries. The Hamburg rules do make the carrier liable for delay, and they also have a definition, explicit definition of what delay is. And delay in delivery is when the goods have not been delivered at the port of discharge, either within the time expressly agreed upon, or if there's no such express agreement, then within the time which would take a reasonable, which will be reasonable to require of a diligent carrier, having regard of the circumstances of the case. A quite standard definition of what delay is, which you also find in other conventions like the CMR convention, which you also find in national, in domestic legislation, etc. So either you have really an agreed time for delivery, or In ocean carriers, that is a bit rare. If you don't have an agreed time, then you look at what would be a reasonable period. Written notice is absolutely required under the Hamburg rules within 60 days. Again, that is standard, that is common. For delay, if you do not explicitly tell the carrier, well, you are now in delay and I'm going to hold you liable, then your claim disappears. You don't have the Rotterdam rules, not in force, of course, and some people wonder whether they ever will become enforced, but still, it's remarkable. The Rotterdam rules also have a provision on delay, but they only say delay in delivery is when the goods are not delivered in within the time agreed. No mention of a fallback position of a reasonable time period. It's only if you have an agreed delivery period that you can have delay under the Rotterdam. In this respect, there's a distinction or difference, of course, between the Ever Given itself and the other vessels. And the other vessels were not blocked as such; they simply had to wait. And as I already said, from an economic perspective, from a commercial perspective, very obviously, the cargo on board of those other vessels was delayed. From a legal point of view, on the other hand, there is not necessarily delay. You could make an argument to say that once the Ever Given had run upon ground, once the canal was blocked, and then even for the most diligent of carriers, there was nothing to do. Either you wait there until you can pass the canal, which is going to take time, or you take the detour around Africa, which is also going to take time. So once the canal is indeed blocked, even the most diligent carriers would need more time to get the goods from where they started to the destination. And in delay, as we've seen, you talk about a diligent carrier, having regard to the circumstances of the case. So you need to take all of those circumstances into the maybe amazing result is that for cargo on board of those other ships, even though they were in fact clearly delayed, they might not necessarily be delayed in the legal sense of the term. Now, when we're talking about delay, it's important to be clear about what exactly are we talking about. Delay as such is, of course, the fact that the voyage takes more time than foreseen. The damage of delay as a type of loss or damage, then you're talking about immaterial, purely financial loss. If you have goods that, because of the longer duration of the voyage, are damaged or lost, and the obvious example is foodstuffs and fresh produce, etc., etc. Goods that have a sell-by date, and normally when they arrived at destination, you would have been able to sell them for 12 months. Now, because of the delay, you can only sell them during a period of 6 months, things like that. Then you are talking about physical loss. You're not talking about delay damage anymore. You're now in the category and in the rules under the conventions that deal with physical loss. What might also happen is that during the extended duration of the voyage, during this period of delay, you now get something else happening. The Ever Given clearly was delayed for a period of time, then ultimately it arrives in Rotterdam, and during discharge, one of the containers is dropped. Well, that clearly is loss, that is damage, but it's not damage that is completely separate. That is not causally related to the delay. That will not be treated as delay damage. If we look at the insurance cover, can you have cover under your policies for this delay damage? Well, if you're in the situation that the delay as such causes physical loss or physical damage, that we're back to the normal situation, you're back to the standard rules on physical loss or damage, that is in principle covered, provided, of course, that the delay was caused by an insured peril. If the delay was not caused by an insured peril, and that delay then causes physical loss or damage, well, then you will not have cover for that physical loss. If you have an all risks cover, like Institute Cargo Clauses A, then it will be quite easy to prove that the delay was indeed caused by an insured peril. If you have a named perils policy, Cargo Clauses B or C, then you will indeed need to show that the delay was caused by one of those named. You could say for the ever given, for the cargo on board the ever given, well, that's quite easy, because one of the named perils in both B and C is vessel or craft being stranded, grounded, sunk, or capsized. Ever given was clearly stranded, grounded. So we are talking about delay caused by an insured peril. The underwriter might say, wait a minute, as Rina said, in the underwriters, suddenly if the amount of at stake is high enough, are going to try and look for defense. Underwriters might say, well, wait a minute, the stranding, the grounding, that was 6 days in March. All of the delay after the 29th of March, between the 29th of March and the 7th of July that the vessel was actually released, the cause of that delay is not the stranding anymore. The cause of that delay is capture, seizure, arrest, etc., which is an exclusion. And you get into discussions about, okay, is there one single delay which found its cause in the grounding, or are there basically two delays? One short delay of 6 days due to the grounding, and then a much longer delay of a couple of months due to capture, seizure, etc. And then you get, as Redian said, into those causation issues, causation discussions. And now, all cover your eyes because I'm now going to say something that's very heretical. Causation in law is a choice by the court. And you can give it all sorts of fancy names like causa proxima and causa proxima inefficiency. I mean, that's just window dressing. It's a choice by the court. It's as simple as that.
You know, it's being.
Yeah, okay, well, those people at home should also cover their eyes then. Okay, another thing for the insurance cover that is not terribly problematic. If, as a cargo owner, you notice that your cargo is being delayed, then your cover will almost automatically extend during the duration. Cargo insurance normally covers your cargo during the voyage, and the insurer expects that voyage to last 3 weeks, 4 weeks. Well, if there is delay and it now takes 3 months, in principle, that's not a problem. Your cover will remain in force during the delay. You may have to pay an additional premium for that. And the Dutch and the French policies, for example, explicitly state that the insurer in such case may ask for an additional premium. Belgian cargo policy explicitly states that such an extension is without surcharge. So even though the voyage takes longer than foreseen, you remain covered. And under the Belgian policy, you don't even have to pay extra. Now, the real troublesome question in this context is when we're talking about delay in the real delay damage in the real sense, purely financial, immaterial loss. You have had to wait for your cargo for longer. Maybe you have had you've incurred penalties yourself because you couldn't deliver the goods that are on the ever given to your own customers. The ICC, Institute Cargo Clauses, what do they say? They say loss, damage, expense caused by delay is excluded, even if that delay is caused by a risk insured against. But no cover for loss, damage, expense caused by delay. There is one, at least a theoretical exception, unless those losses, damages, and expenses are recoverable in general average. And the general average is covered, and via that roundabout, basically, you could recover it. But with regard to general average, all of the exclusions in clauses 4 to 7 remain in force. And again, one of those exclusions is the capture seizure risk. So even if you tried to recover losses, damages, expenses, etc., through general average, you might still come up against the capture defense, etc. Our French friends go even a step further. Their policy quite explicitly states that only physical loss or damage is covered. So that's the scope of the cover is physical loss damage, plus some specifically named costs, not physical loss, but costs. But delay is not mentioned in those clauses, those terms of the policy that add those costs. And as I said, they even go a step further, because this exclusion for delays is quite common. Then it's also in the ICC. They say if you have physical loss or damage that is caused by delay, the foodstuffs that have spoiled, even that is excluded, unless the delay that has then caused physical loss or damage, unless that delay was caused by a quite limited list of specifically named parts. Belgian cargo policy says loss, damage, and expenses due to delay not caused by an insured peril are excluded, unless otherwise agreed. You are insurance, as Renian said, is a contract, so you can basically agree whatever you want, insure whatever you want. You might think, well, it says due to delay that is not caused by an insured peril is excluded. So then that must mean, a contrario, that if you have delay that is indeed caused by an insured peril, then that is covered. But no such luck, because that is then covered by another exclusion that is then considered as indirect or consequential loss, and that is also excluded. So also under the Belgian cargo policy, as under the ICC, basically as under the French policy, no cover for delay, loss, damage, and expenses due to delay. Basically, the only somewhat exception is in the Dutch cargo policy. It says loss, damage caused by delay is covered if you have a double requirement that is met. The delay that has then caused the loss or damage must have been caused by an insured peril, and the vessel carrying the goods must have been damaged as a result of this. So they're still requiring some kind of physical loss or damage of the carrying vessel. And if that is the case, then you can get compensation for loss. But as you see, I think it's clear from the policies, insurers really do not basically want to cover delay. That's something they are going to shy away from, probably because it's so unpredictable, and you can ask for, or delay can provoke a lot of difficult to predict liability. Now, German market, the the basic policy rather doesn't cover delay, loss or damage either. But they have developed what they call a pure financial loss clause. Vermögensschadensklausel in. Cover a clause specifically written, specifically meant to cover delayed damage. Because as we've seen in the Belgian policy, it says unless otherwise agreed. So if you want to obtain delay cover for damage through delay, you can. I mean, it's if you find an insurer who is willing to sell you that kind of cover and you're willing to pay the premium, then you can. There's a case about this pure financial loss clause and the ever given. It's a decision of the Landgericht Düsseldorf of July 2022 rather. What happened there? A German company had bought a consignment of synthetic fleece, something that they were going to use to produce mouth masks. That synthetic fleece was being shipped from China to Germany. It was, in principle, expected to arrive early April 2021, but unfortunately, that synthetic fleece happened to be on the Ever Given, so it, in fact, only arrived in Hamburg in mid-August 2020. This type of synthetic fleece had, because it was meant, it was not just simply plastic that you could basically continue to use whatever. This was a rather specific type of thing meant for use in health and safety products. So it only had a shelf life of 12 months. So I said, well, the commercial value, since it has been delivered so late, commercial value has diminished by 50%. Our German buyer, since he himself had obligations to his customers, had bought replacement fleece to be able to continue production to deliver. And since that fleece was going to be used in health and safety products, he had taken the precaution of having the fleece tested before he acted. The fleece that ultimately was delivered in August from the Ever Given, he had that tested as a sort of precaution to make sure that nothing had happened to it during the stay in on the board. Yeah. Our German buyer was insured under a German policy and with such a pure financial loss clause added to it. So we think this guy has been has had foresight. He has indeed obtained cover for delay damage. He'll get his money, right? That the insurer said, no, you don't get your money. And the case ultimately went to court. And the Landgericht said, no cover. No, you have a specific pure financial loss clauses, circumstances which would seem to point to a rather obvious case of damage by delay. But no, you don't get money from the insurers for several reasons. Why? That pure financial clause, a loss clause, says there is only cover under this clause if the carrier is liable under the terms of a standard forwarding contract under German law. That is the literal wording of this clause. We talk about rather strangely about a forwarding contract rather than a contract of carriage. It's unclear. The German insurance law authors, insurance law professors they don't know that themselves. It's unclear whether this means that your forwarding contract, that is generally accepted, you need to understand that in a very large way. So it also includes contracts of carriage. But under German law, what does that mean? Does that mean that this contract must have been actually subject to German law? because of a choice of law provision, because of the rules of private international law, but actually subject to German law and the carrier liable under German law? Or is it sufficient that the carrier would have been liable if, hypothetically, German law would have applied? That to me seems rather essential, and I don't think it's a good sign if this kind of interpretation or construction issues are unresolved. The court, the German court says, well, we are not going to decide on this issue either. We don't need to decide on this issue either, because in any case, a carrier would have been able to invoke the multiple fault exemption, which would be included in a standard forwarding contract. So they said, well, basically it doesn't matter, even if you say, well, it's not actually subject to German law, so in any case there's no cover, or you say, you take the second, the broader opinion, in that case, the carrier would have been exempted. So on that reason already, since the carrier of the goods on board of the Ever Given would have been able to invoke the notable fault exemption, no cover under the pure financial loss laws. Plus, the court says there is an explicit exception in the pure financial loss laws. Excluded are losses caused by confiscation, deprivation of possession, or other acts of authorities. Again, we get the question before the court, well, what exactly do these words mean? What exactly is that? And the court says, well, this basically refers to any type of act of the authorities that restricts cargo owners' normal powers. The claimant, in this case, so the German buyer who had incurred damage by delay, who wanted money from the insurer, had said, no, you need to make a distinction, distinction between authorities acting for what they called civil law purposes. The Egyptian authorities, the Suez Canal Authority, basically trying to get money, trying to secure a claim for money. That would have been according to the claimant's civil law purposes, and authorities acting for public law purposes, for health and safety, for safety of navigation, things like that, to stop terrorism. Of course, there's no basis for such a distinction in the wordings in the terms of the policy. It's any type of act. Very clearly, if the authorities arrest a vessel, stop it from leaving Bitter Lake until the claims are resolved, that very clearly is an act that restricts the cargo owner's normal powers. The claimant also said, quite a well-known argument, claimant says, well, the owners should have given a guarantee. Once the vessel was arrested by the Egyptian authorities, well, okay, we can accept a couple of days, a week maybe, but then the owners should have given a guarantee. If they had given a guarantee, then the vessel would have been released and the delay would have been much shorter. So it's actually a fault, it's negligent of the owners not to give a guarantee. The court says, based on a translation of the actual arrest order from the Egyptian order, says no, because in this case, it was not only quite remarkably, was not only the vessel, but it's also the cargo that apparently had been arrested. In standard cases, so to say, it's the vessel that is arrested, but not the cargo on board of the vessel. Here, apparently, also the cargo had been arrested. So the court says even if the owner had given a guarantee for the vessel, that would have not procured the release of the vessel. So no fault of the owner. Third reason that the court says there is no cover. Court says, well, under German law, a carrier is only in default, is only late in delivering the goods if you have agreed a delivery date. There was no delivery date agreed in this case, so that was not relevant in this case. Or after notice has been given. After cargo interests, the claimants have said, well, this is taking too long. I am putting you on notice. I'm giving you notice that I want my goods delivered by this date. And if you don't do that, then you will be in default. And the German claimant, the buyer, had indeed given notice, had explicitly given notice to the carrier, but on the 21st of July. And he had, on the 21st of July, he had then said, deliver my goods no later than the 29th of July, or you will be in default and I'm going to hold you liable. And the goods had actually been delivered on the 13th of August. So still somewhat after the deadline. But the court says the damage that you are claiming as a German buyer, all of that damage had already occurred, had already been occurred before you gave notice, before the carrier was in default. For example, you have bought replacement goods so that you could continue production, you could deliver to your own customers, but you bought those goods already in May 2021. So months before you gave notice, months before the carrier became in default. Courts didn't need to go there, but I think this is a very good reminder that you need to be careful indeed. If you want, in circumstances like that, if you want to be able to hold a carrier liable, this guy should have given notice, even though it was clear that in May or in April 2021, it was impossible for the carrier to comply with the deadline. He should nevertheless have given notice then to save his possibilities of claiming late. Conclusion with regard to delay. Very difficult to get insurance cover for that. You can if you really want to, but even then, even if you have such a pure financial loss clause like in the German market, even then it's not guaranteed that you will get loss. You still need to be very, very careful and be mindful that you take the right steps at the right time. Very briefly to conclude, general average. You undoubtedly all know what general average is, and that's an old mechanism. Well, it dates back a very long time, but it's still in force today. It still applies today. It's basically to share unforeseen expenditures between the participants in the maritime adventures, primarily the ship and the cargo. You might have other vessels, freight, etc. The owners of the Ever Given have indeed declared general average. What that will come to, I mean, it's totally, if you're talking about this many containers, this many interests, making, adjusting DGA, preparing DGA adjustment takes years. We will not know for some time whether what the result of that will be. Suppose that at the end of the day, the outcome is, well, cargo has to pay X amount of millions of dollars for as a partial compensation, as a contribution to the expenditures of the doesn't necessarily mean that the cargo then actually have to pay. That's the York-Antwerp rules, standard rules to deal with general average. Provided defense in Rule D, cargo can invoke all remedies and defense. Could maybe try to argue that the Ever Given was unseaworthy or something like that, and that would be a defense. Furthermore, York-Antwerp rules are not mandatory. The parties can agree differently. And BIMCO, for example, has proposed a general average clause which says that cargo's contribution shall be paid even when such average is a result of fault, neglect, or error of the master pilot. Right? So you are able to contractually annul basically or override rule. From the insurance perspective, that's my last point. There might be a further defense. But don't get your hopes up because it's a very difficult defense. In some cases, you are able to say that the parties have agreed what has become known as an insurance code or an insurance fund. Several cases about that. The most recent one is the Polar decision by the Supreme Court. What happened in the Polar, the voyage charter party? The vessel was hijacked by Somali pirates. You see, piracy is coming back over and over again. The owners paid $7.7 million in ransom. They declared general average to recover part of that money from cargo. Cargo contribution would have been, according to the adjustment, would have been some almost $6 million. Now, issue was what the cargo owners tried to invoke as defense. Issue was that the owners had taken out KNR, kidnap and ransom insurance. Insurance specifically covering ransoms to be paid to parties. And the premium for that insurance was going to be paid by the charters. And the charter party explicitly stated that there would be kidnap and ransom insurance, and the premium would be paid by the charters. So the charters said, well, the parties, in this case, the owners and the charters, they have arranged, they have agreed to have, for example, an insurance fund. We have both of the parties, the owners and the charters, they have arranged it so that there would be insurance money, an insurance fund available. And if you have claims, if there is a ransom to be paid, well, then you need to look to the insurance, to that insurance fund, but not afterwards claim, in this case, via the detour of general average. You cannot claim that from the charters anymore, because there was a previous agreement between the parties that if something like that happened, they would only look to the insurance and not to their contractual counterpart. And there are other cases, the EVA number 2, for example, the Ocean Victory. There are other cases where indeed such an argument was accepted. In this case, ultimately the Supreme Court said no. In this case, there is no such agreement between the parties. You might have, the parties may agree that if they clearly and knowingly do that, but in this case, based on a construction of the charter party, etc., no, we are going to say no, there was no such agreement between the parties. So even though the owners had kidnap and ransom insurance, which had been paid by the charters, afterwards the owners could still use the mechanism of general average to recover, basically the subrogated insurance, of course, could still recover general average mechanism to recover part of that ransom from the cargoes. That's what I wanted to tell you today. Thank you for your attention.